I'd like to welcome everyone to the second of Carter's Spring 2025 Charity and Not-for-Profit webinar series on today's topic of key legal and operational issues for donor-advised funds. Hello, my name is Terrence Carter, and I'm the managing partner of Carter's, and I'll be your moderator as well as a presenter today. We are delighted to have more than 560 people registered for the webinar, along with our other presenters, Jacqueline Dempscher, Malcolm Burrows, and Nicola Elkins. Carter recognizes that its work and the work of its community partners take place on traditional Indigenous territories throughout Canada. We acknowledge the 46 treaties and other land agreements that cover what is called the province of Ontario. We are thankful to work and live in these territories and acknowledge the enduring stewardship of First Nations, Métis, and Inuit people who have cared for these territories since time immemorial, and who continue to contribute to the strength of Ontario and to communities in all provinces and territories across Canada. The presentation handout for today's session was sent to you along with the 24-hour and 1-hour emails that you should have received. And the video replay will also be available on our YouTube channel within 24 hours after the webinar. If you're printing the presentation slides, you should do so using the slide deck sent to you 1 hour ago, as it corrected a few glitches from the one sent yesterday. Given the limited time we have for this webinar and the amount of materials from our 4 presenters that we would like to share with you, we will not be able to take questions from attendees. However, we will have a 15-minute panel discussion after the PowerPoint presentations that will raise a number of the more common questions that come up involving practical aspects of working with donor-advised funds. As your host, Carter's is one of the leading law firms in Canada in the area of charity and not-for-profit law, and has offices in Toronto, Ottawa, and Orangeville. For more information about our firm, please visit carters.ca, and also feel free to sign up for our monthly newsletter. I'd now like to introduce my co-presenters today. Jacqueline Dempscher is a partner at Carter's and practices in the area of charity and not-for-profit law and has considerable experience in writing about, setting up, and advising on donor-advised funds. Malcolm Burrows is the head of philanthropic advisory services with Scotia Wealth Management and is the founder and executive director of Aqueduct Foundation, a donor-advised fund holding charity. Nicola Elkins is the president of Cause Strategies and is the founder and CEO of Benefaction Foundation, which is also a donor-advised holding charity. We are extremely fortunate to have both Malcolm and Nicola as part of our webinar today, as they will be able to provide much needed practical context for our discussion as a result of their daily work with donor-advised funds to supplement the legal framework that Jackie and I will be addressing. Please note that this presentation does not constitute legal advice, and attendees are encouraged to speak to their own legal counsel to obtain advice as necessary. We'll now start the presentations. Jackie and I will begin with our presentation on donor-advised funds, an overview of key legal issues, which will take about 30 minutes. Nicola and Malcolm will then present on their topic of donor-advised funds, an overview of key operational issues for about 40 minutes in total. After that, we will move into a panel discussion involving all presenters for about 15 minutes for a Q&A time. We will end sharp at 1:30 p.m. Now we're going to get into the presentations, and I'm just going to pull up the slide deck for today and start our discussions together. So on the topic that Jackie and I are dealing with an overview of key legal issues, the question that comes up is, there's a real significant interest in donor-advised funds that has developed in the charitable sector over the last number of years. That comes either from charities that want to set up DAFs, charities that want to transfer funds over to DAF holding charities, to financial institutions wanting to set up DAFs, as well as donors who want to be able to contribute to establish a donor-advised fund. And of course, there's always the regulator, Canada Revenue Agency, who is interested in what's happening with the DAFs that are being set up. If you want to get some information about some of the legal issues involved with donor-advised funds, Jackie Dempsey has put together a really good paper, a primer on donor-advised funds and current issues, and we've given you the link to it. So what we're going to do, Jackie and I, we're going to talk about why DAFs are so popular, what they are at law, and some of the case law that surrounds them, as well as look at sort of a review of some of the legal issues related to DAFs. And then finally, we'll talk about some of the practical considerations in moving and working with DAFs. So what is a DAF? Well, a DAF is a charitable giving vehicle, and basically it involves the creation of a fund by a donor, making a gift over to a charity, which we'll call a DAF holding charity. Canada Revenue Agency has recently provided a definition of DAF, so it's always good to go back to the regulator to see what they say. And what the regulator says is a DAF is a fund segregated into donor accounts, owned and controlled by a registered charity. Each account is comprised of contributions made by individual donors, and donors may provide ongoing non-binding suggestions on payout from DAFs. But it's the charity's sole responsibility to make such decisions. So we always want to keep that in mind, what the regulator has to say. And so the funds are established by a donor, maybe by a family, and then the charity will then distribute funds out of the DAF and move it over either to registered charities, other registered charities, or to, which we'll talk about, grantees that are basically non-charities by means of making grants over to them. And so the key aspect of a donor-advised fund is the role of the donor. The donor gets to have input. The donor doesn't control, but the donor is able to provide advice concerning distribution of funds, whether it be income or capital, out of the donor-advised fund. What is really important, however, is to understand it's not an account of the donor. It's not a fund of the donor. It's a fund of the charity to which the monies have been given. So at the end of the day, it's important to keep in mind that the charity who received the funds for the DAF is in charge. It's their property, and they have responsibility to manage those funds as their charitable property. This is just a bit of a graphic to show. We've got our friendly donor over here making a donation over to a DAF holding charity for a donor-advised fund. The donor gets back a receipt. Why? Because it's a full gift that's being made. And now the DAF holding charity will make grants or make gifts over to charities. It can even be to non-charities under the granting program, and will then seek advice back from the donor in moving forward with it. So now we're going to move over to Jackie, and Jackie's going to walk us through a little bit about why it's popular and some of the other issues. Over to you, Jackie.
Great. Thanks, Terry. Hello, everyone. I'd like to talk to you a little bit about why DAFs are so popular now and have been for the last number of years. And one of the key reasons is that they are a practical and appealing alternative for donors who may not have either the financial resources or the ability or the interest or time to set up and then operate their own private charitable foundations. By contrast, it's relatively inexpensive for a donor to establish a DAF within a DAF holding charity versus, as I say, setting up their own private charitable foundation. You'll see in the boxes at the bottom of this slide that there's many DAF holding charities that don't impose even a minimum initial donation, or if they do, it can be as low as $5,000 or some similar amount, with then the ongoing annual fees to have your DAF with the DAF holding charity also being moderate. By contrast with private charitable foundations, assuming they're going to hold an endowment, you need to have likely a $2 to $3 million capital asset base to generate enough income for it to make annual gifts from that income. And then you'll have to deal with the annual operating costs of the private foundation, financial audits, T3010s, holding annual meetings, and so on and so forth. Another key feature that makes DAFs popularity is the anonymity that can come with them if that's desired, and the flexibility in their structuring. So let's look at what a DAFT is at law and what the gifts that go into a DAFT are at law. First, the donor's going to be making, when they set up the DAFT, they're going to make an initial and then later ongoing gifts to their donor advised fund. Those gifts are going to be charitable gifts, and under the common law, a charitable gift is a voluntary transfer of property owned by the donor to the donee for which the donor received no consideration. In addition, the donor, when making the gifts to the DAFs, can make them restricted charitable gifts. Unrestricted charitable gifts that come into a charity need to be applied to a charity's charitable purposes, but there's no other donor restrictions that are imposed and have to be followed by the charity after the gift is made. But with restricted charitable gifts, this is when the donor makes the gift and at the time of making it imposes certain restrictions on how the gift is to be held and managed and then utilized, and they do that from the outset. And when they do that, those restrictions constrain or limit how the charity can use the gifts in the DAFT going forward. We also want to make sure that the gift from the donor satisfies income tax requirements. The CRA accepts the common law definition of a gift that I set out at number 1 above, and any gift that meets all income tax requirements can be receipted, and then that charitable donation receipt used by the donor against their income tax liabilities. So how does this all relate to a DAFT? Terry's given us a little bit of an overview of how the DAFT works, but I'll go over it again here. The original gift that comes from the donor to set up their donor advised fund in a DAFT holding charity can come in unrestricted, or the donor can impose one or more donor restrictions that will go into the gift agreement setting up the DAFT. What makes it a DAFT, though, is that there's this extra feature that's layered on top of that gift, and it's called the donor advised feature. It allows the donor and possibly successor fund advisors, if that's permitted by the DAFT holding charity and authorized by the donor, to provide ongoing advice to the DAFT holding charity on various aspects of the DAFT. The key one is advice on how the income and or capital from the DAFT can be used to make gifts to qualified donees or possibly grants to non-qualified donees. But it's important to remember the donor advised feature doesn't impose a legal obligation on the DAFT holding charity to have to act as the donor advises. That being said, there's certainly a moral obligation for the DAFT holding charity to consider all donor suggestions that come in as part of their decision-making process. This key feature of DAFs is very important for DAFT holding charities or any charities that are considering putting donor advised funds in place to clearly inform their donors from the outset that the advice, the input, the suggestions they provide are advisory only, and all decisions are ultimately made in relation to the DAFT by the charity. This is so important because all the donations that come into DAFs need to be true gifts at law so that they can be properly receipted under the Income Tax Act. And it's also fundamentally important because the DAFs are the charity's own charitable property over which they have legal and fiduciary obligations to exercise ongoing direction and control. If too much control is provided to the donor over the gifted property in a DAFT, then it could lead to CRA considering the gifts made by the donor to be defeated or negated. That would end up nullifying the receipts that have been issued and cause potential tax issues for the donor. So there hadn't been much case law about donor advised funds until 2022. And in 2022, a decision came out in the Joseph Lebovic Charitable Foundation versus the Jewish Foundation of Greater Toronto. This was the first case in Canada that discussed donor advised funds at length. And in its essence, it upheld the commonly understood conception of a DAFT as we've provided in our introductory slides. So in this case, the key facts are Mr. Lebovic set up a DAFT with the Jewish Foundation. He passed away, and his brother assumed responsibility as that DAF's fund advisor. There was a dispute about how the monies in that particular DAF were to be applied by the Jewish Foundation. And the brother brought a motion to the court to try to prevent the foundation from spending a small portion of the funds in that DAF, contrary to his requests. The court looked at everything and found that the brother lacked grounds for his motion and stated very clearly that unless restrictions are imposed at the time gifts are made to a DAFT, the donor cannot later direct how any of the charitable gifts from that DAFT are spent by the recipient charity. So we're going to look now at some key legal issues associated with DAFs. The first one, and this goes back a few years now, was this idea that charitable assets are languishing in donor-advised funds. And this was an issue that the Special Senate Committee on the Charitable Sector looked at closely as part of their study of charities back in the late teens. And in the report that the Special Senate Committee released, they discussed DAFs, among other issues, and recommended that consideration be given to putting means in place that these donations and donor-advised funds don't languish, but are instead used to fund charitable activity in a timely fashion. Now, this recommendation by the committee has been criticized in the sector somewhat as conflating how DAFs work in Canada with certain features of how DAFs work in the US. And in the US, DAFs can be used as a loophole for private foundations to avoid minimum payout requirements, but this isn't the case under Canadian law. And in the next slide, we're going to review two key features under the Income Tax Act that allow assets not to be languished. You can do the next slide, please. So specifically in Canada, there are legal requirements that there needs to be annual disbursement quota requirements that are satisfied by charities. And disbursement quota, we call it DQ for short, is the minimum calculated amount that a registered charity is required to spend each year. We'll talk about the details of the DQ shortly. The other key mechanism under the Income Tax Act are there are inter-charity transfer rules which prohibit transfers between non-arm's length charities, which are done for the purpose of avoiding minimum disbursement quota obligations. Where transfers of this kind happen, then the Income Tax Act will require there be deemed disbursement out of those funds. So given these requirements, it's not clear what the specific concerns about assets languishing in DAFs is about in Canada. Just as a comparison, lots of charities hold other types of funds, such as endowments, where the capital of the fund is held in perpetuity, only the income spent, or other types of restricted gifts, where the donors set them up, put monies into them, get immediate tax benefits, but the distribution of the assets from those funds takes place over time. So very similar to how DAFs work. Related issues, making sure that there's appropriate investment of any funds that are held in DAFs in accordance with any initial restrictions imposed by the donor, but more importantly, the applicable investment powers of the DAFT holding charity. You'll see a link to a paper here with more information about investment power issues for charities. So then a little bit more about the DQ. Going back to January 1st, 2023, there was an increase in the minimum DQ payout that charities have to do each year. You'll see at the chart at the top, for charitable foundations that have property that's not used for their charitable activities or administration over $25,000, as well as charitable orgs who have property over $100,000 up to $1 million. There's a minimum 3.5% disbursement quota requirement. Where property for these charities is over $1 million, then the DQ goes up to 5% each year. It's important, though, to recognize a DAFT holding charity meets its DQ obligations in any given year on an aggregate or global basis, based on all of the assets that they hold, not on a fund-by-fund basis. However, there are some DAFT holding charities that set their own internal distribution rate on a fund-by-fund basis. So if you're setting up a DAFT, you want to explore what the rules are in the particular DAFT holding charity that you're contacting. there's been some questions or suggestions raised that maybe individual DAFs held by DAF holding charities should be required, actually under the Income Tax Act, to disperse a minimum amount of income each year. That's not in place now, but there's suggestions that it should be. But if that was to happen, then it may also apply on this fund by fund basis to charities that hold endowments or other restricted funds. And they may not, particularly for historic funds, have the ability based on the gift agreements to generate enough income to meet that higher disbursement quota. And they may have to get a court order to encroach on capital or realize capital gains in order to do so. So I'm going to turn it over to Terry now. Oh, I'm sorry. I got one more slide. I forgot. Practically speaking, and Malcolm and Nicola will talk about this more, based on some research done about DAFs, it's actually estimated that only 10% of DAFs hold assets over $1 million. So in theory, if there was to be an imposition of a DQ at an individual DAF level, DAF holding charities would actually have a lower overall obligation given the 3.5% DQ rate for assets under $1 million. However, it would result in more administration for the DAF holding charity because they'd have to make sure that each and every individual fund is distributing that minimum amount each year. It's also from the research from the 2023 CAGP report that the average granting rate from DAFs in DAF holding charities and other charities in 2001 was actually 10% of their assets, which was well above the 5% disbursement quota requirement under the Income Tax Act. I'm going to skip this last point. I'm going to turn it over to Terry to talk to you about some more legal issues that DAFs generate.
Great. Well, thank you, Jackie. And just to put it in context, charities that were holding DAFs have not until recently been required to report them to Canada Revenue Agency. That's changed as of January of 2024. Those on the webinar today involved with charities will know each year you need to file your annual return, the T3010. Well, as of January of 24, now you will have to answer a series of questions in the event that you're holding DAFs. And so the first question that you have to answer is whether or not you've got any DAFs. And if you do, then you have to indicate the number of DAFs that you're holding, the value of the DAFs at the end of the fiscal period, the total of donations that have been made to the DAFs during that period, as well as the value of, quote, qualifying disbursements, quote, which I'll explain in a minute, from DAFs during that period. It doesn't talk about all disbursements. It just talks about qualifying disbursements, which is a good lead-in to the issue that we think needs to be considered when talking about DAFs, which are, well, what are qualifying disbursements, and does it have any application to how a DAF holding charity would operate? And it does. In June of 2022, there was a helpful amendment to the Income Tax Act that many of you will be aware of, pushing towards more flexibility in what charities can do. So instead of just cutting checks to other charities, qualified donees, or doing own activities, now charities can make grants, or in essence gifts, or otherwise make resources available to non-charities, to technically non-qualified donees. So think about community organizations in your community, think about organizations overseas. So it's really expanded the opportunity to do things with charitable funds. But there are three requirements, and we set them out on the slide here. You've got to make sure that the grant to the non-charity will achieve or will further the charitable purpose of the granting charity. You've got to make sure that the activities that are carried out by the recipient, the non-charity, again, will be furthering the charitable purposes of the granting charity. And you've got to make sure that you're able to document all of that and be able to show it to your friends at Canada Revenue Agency. And so if you're a DAF holding charity and you're thinking about wanting to be able to offer the option of grants to non-charities, to grantee organizations, you will need to work with your legal counsel because if your charitable purpose has been in the past just to make gifts over to other charities or qualified donees, that's not sufficient. You'll have to have common law purposes that will allow you to relieve poverty, advance education, and so forth. But once you have those purposes, then you will have the ability to make grants. And when you do, CRA does have a guidance that they put out in December of 23 that focuses on the methodology, and they talk a lot about risk with risk matrix and accountability tools. That's for another day to go through that. But just keep in mind that that DAF holding charities can make grants over to non-qualified donees, provided it complies with the requirements that are in place under both the Income Tax Act as well as under CRA's guidance. Another issue to keep in mind, in June of 2022, same kind of active time for amendments to the Income Tax Act, new provision was introduced called the anti-directed giving provision that basically says that if a charity accepts a gift, the granting of which, quote, was expressly or implicitly conditional, quote, on the charity making a gift over to a non-charity, so a non-qualified donee, then the charity can lose its charitable status, so not to be taken lightly. That becomes a relevant factor when you're looking at having monies come in the door into a DAF holding charity, but the donor is thinking, well, really what I want you to do is to now make a grant over to a non-charity, a non-qualified donee. Does that run the risk of being contrary to the anti-directed giving provision? And the answer is, well, it depends, a good lawyer's answer. If the DAF holding charity is making it very clear they're in control, they're making the decisions, sure, you can make suggestions, but it's up to the DAF holding charity. You probably won't run into problems with it, but we just mention it because it is an issue when either you're making gifts to DAF holding charities or you're running a DAF holding charity, or you're thinking of having funds come to you through a DAF holding charity. You need to be aware of the provisions. I want to turn it back over to Jackie to go through some of the other issues that need to be looked at.
Sure. So the next topic on our list are granting policies. This is a common type of policy that a DAF holding charity will have in place. And it's important for DAF holding charities to make sure that the gifts that come from the DAFs over to recipient qualified donees, which include charities, are not offside of the Income Tax Act. If they are, then that could result in complaints to CRA from the public, which could then lead to audits and then could lead to possible sanctions and penalties. In addition, some DAF holding charities place limitations on the types of qualified donees that are able to receive gifts from their DAFs that may flow out of the charitable purposes of the DAF holding charity, or just restrictions that the charity puts in place from time to time. And they could be or could involve geographic restrictions, like in a local community foundation, or religious restrictions, cultural, philosophical, or they may be program-based if the DAF holding charities focused on a particular type of area in charity, whether it's education or the arts or healthcare. So very important, though, that the DAF holding charity puts all these restrictions clearly set out in their grant policy or guidelines. They make that grant policy or guidelines available to donors, and then they cross-reference that granting policy or guidelines in the DAF agreements themselves. The granting policies also often address how gifts from DAFs can and cannot be used. I've worked with charities to set up granting policies to make clear that gifts from a donor's DAF can't go over to other charities to pay for tickets that donor is purchasing at a fundraising event for another charity, or to pay for school tuition related to the donor's children at a school that's a charity. But it's not enough just to have the policy in place. You need to make sure that there's ongoing monitoring and enforcement by the DAF holding charity. Another key policy to have in place, as well as a robust gift acceptance policy. Every charity should have that has active fundraising that sets out, what type of gifts the charity's interested in receiving or able to receive, what gifts it cannot receive, and what the standard protocols are in accepting those gifts and administering them going forward. Another issue, I'll just touch on it here because Nicola's going to talk about it in a bit more detail, but a key legal issue to discuss with DAFT holding charities and donors setting up DAFs are successor fund advisors. So as we've explained, when the donor sets up the DAFT, it has this feature that the donor can provide ongoing advice for the DAFT holding charity to consider in making gifts or grants out. But where the agreement is silent, then the donor's attorney under a power of attorney or the executor if the donor passes away might have the ability to act as a successor fund advisor. The key is you want to address these issues in the DAFT agreement or at least in the policies of the DAFT holding charity that are cross-referenced in the agreement so that there's not uncertainty going forward. As well, you can address various scenarios. What to do if the donor doesn't designate a successor, how many times successor fund advisors can be appointed, what to do if there's contrary gift recommendations coming in from multiple successors, and who's eligible to be a successor fund advisor. And then again, I'll just touch on it. One criticism or concern raised about DAFs in the sector is about this idea that they facilitate anonymous donations. And some of the recipient charities of gifts from DAFs raise concerns about the ability of a DAF donor to remain anonymous from them. I'm not sure how practically often that happens. Malcolm and Nicola can speak to that issue, but it is a concern out there on the part of recipient charities of gifts from DAFs. They would like to have a connection to the donors who are making the gifts through their DAFs, as well as have more information about who that donor is in the event they have to decline the gift for any reason. So in the last few minutes, I'd just like to conclude with some practical advice from the lawyers for charities that are working with DAFs. And then this will segue well into the operational issues that Malcolm and Nicola are going to talk to you about. So if you think that you're going to be involved in DAFs in any way, you want to do your homework ahead of time. You want to do due diligence to know if how to manage DAFs, how to do it correctly under tax and trust law, and make an informed decision about whether to get involved in them or not, or if you're even tangentially connected to DAFs, knowing how they operate so that you can better understand the process. If you decide in your charity to accept DAFs from donors, you want to create template documents. You want to have a good gift acceptance and granting policy in place related to your DAFs and other gifting vehicles. And you want to have template DAFT and gift agreements to cover a variety of scenarios. You want to make sure that your charity runs this process. At the end of the day, the DAFs are your charitable property that your charity is responsible for. So your charity should be in control of the process of setting up the DAFs and making sure there's consistent procedures in place, both in the gift agreement and related policies, and that they're followed going forward. The donor and their legal counsel shouldn't drive the process. And then finally, you want to be vigilant with the language that you use in talking to donors about DAFs. You want to avoid language that suggests that the DAFs belong to the donors. They don't. They belong to your charity once you accept them. That you want to avoid this idea that donors might be clients that have accounts with your charity. That's not correct. And the idea that the DAFT is the donor's own private foundation. DAFs are a really good opportunity for charities to consider. They give you the ability to have ongoing connection and engagement with your donors. And it might be a new way for your charity to attract more gifts and potentially larger ones from donors. Donors really like the flexibility of DAFs. And even if you're an active charity that thinks maybe DAFs don't apply to you, they may be a vehicle that you could use to structure with ongoing donors. They make ongoing gifts, and they may make decisions to fund certain programs that change from year to year within your charity. That's an option to consider. So with that, I will conclude and thank you for your attention and turn it back to Terry to introduce our next speakers.
Well, that's great, Jackie. Thank you very much. And you're right on time. So that's really good. So what we're going to do now is we're going to just move over to Malcolm and Nicola, and they're going to be walking us through their topic, a combined topic, an overview of key operational issues. And so we're delighted to have Malcolm first up. So over to you, Malcolm. Thank you for joining us.
And Terry and Jackie, thank you for both having us here today, as well as that excellent introduction to the topic. I wanted to ground this a little bit. Both Nicola and I are executive directors, founders of foundations with donor advised funds. And it's something, as we get into practical issues within the Canadian charitable sector, we've been co-chairing a working group on donor advised funds through the Canadian Association of Gift Planners. And just so a lot of our comments are coming from there. We've been working very closely together over since January of 2024, bringing together donor advised fund foundations, as well as interested members of the charitable community. We've really been approaching this as how does the sector come together and address and better understand and work through some of the operational issues. So we're convening members of the charitable sector that are interested in this topic. We're also thinking about are there sector positions that we can develop on legal and regulatory issues that relate to donor advised funds in Canada, and really understanding that they're different than the US casts a very sometimes strong shadow on us and defines our thinking. How do we think for Canada is really important. And then looking at some best practices or sort of common practices with foundations for donor advised funds. And we've been meeting regularly. We have a growing membership. It's over 27 members right now. And so I just wanted to put this in context, also to give a quick shout out to Keith Sogren, who's one of the primary researchers in this space. So next slide, Terry, thank you. What Canadian charities hold donor advised funds? So from an operational perspective, it's good to see, and some of the background reading provides some context on this. Approximately 300 registered Canadian charities have multiple donor advised funds. The number is as high as 400 that are self-reporting on the T3010, but it's a question of critical mass. Do you have one or two or three donor advised funds, or do you have a whole focus on donor advised funds? In total, this is estimated this year to be about $12.4 billion in assets. So as noted, a fast growing area. And the average payout rate, again, estimated this year to be about 12%. Most of these entities are public foundations. And it's important to remember that from a practical perspective, these entities, these structures are very much a creation of the charitable sector. It came out of the community foundation movement, first in the States, the Vancouver Foundation, one of largest and sort of real leader in the space, was the first Canadian foundation with donor advised funds starting in 1952. And by far, community foundations are the most numerous or common foundations with donor advised funds, but there's remarkable diversity. And that's one of the key things. If you think one of the standard sort of quips or jokes in the charitable sector about foundations, if you know one foundation, then you know one foundation, because each one is quite different. And so recognizing that difference is very important, and it's something that we wanted to spotlight. What often are associated with donor advised funds these days are financial institutions, that's FI for short, associated foundations. They've been the fastest growing over the last 20 or so years, and there's about 35 or 40 of those. And it's an interesting relationship because of the investment side of things, the planning side of things, and getting that alignment and support for donors with the charitable piece. But it's important to keep those two pieces very separate, because it is not client money, it is foundation money. So, and again, just reinforcing what Terry and Jackie said, can't emphasize this enough. Each foundation defines its donor advised funds based on their own mission and policies. So that it's very much a strong self-definition process. It's not an inherited definition by any means that comes from the Income Tax Act or some other place. And some, for example, just grant to qualified donees or other registered charities, and some to non-qualified donees as well, as noted. But even things like programs or direct activities, charitable activities like scholarships are a possibility. So tremendous diversity is a key theme here. And finally, often foundations with donor advised funds have other types of funds. You think about community foundations, they have many different pockets. And so even our own foundation that I run, Aqueduct Foundation, we have donor advised funds, but we also have other types of funds. So it's important to recognize that first and foremost, foundations with their own policies. So Gary, next slide, please. Thank you. And so again, put it in context, the US does indeed cast a strong shadow on the Canadian charities and probably the country overall. And donor advised funds are important to recognize that they are a US invention. And in the sort of aligned with financial institution, the great change happened in 1991 with the launch of Fidelity's Charitable Gift Fund. And this changed the scale and perception, I would say even the politics relating to donor advised funds, something that had traditionally been an exclusively charitable tool is sometimes seen as a financial product and not a charity fund. And I think that this is a wrong interpretation, but something that we need to address in Canada. It's become the fastest growing charitable structure. And I want to talk a little bit about the practical considerations around this. It's not just a question of legal choices, donor advised funds versus private foundations. It's also a question of who the donors are, what they hold. We've seen a tremendous concentration of wealth over the last 30 and 40 years. And whatever you view about this, it's showing up in philanthropy with larger donations and an ongoing desire for involvement with granting and charitable activities, quite simply because it's almost too many decisions to make all at once with some of these very large donations. And so in the US, you see donor advised funds associated with financial institutions called just DAFs, as if the entity themselves are completely DAFs or donor advised funds rather than a charity with them. Or sometimes they're called sponsoring charities. In Canada, we've tended to take the position that this implies that they are just charities in name only, and too much control rests with donors. And this is a key theme in terms of the ongoing credibility and rigor of our system here in Canada. So in the US, they've become part of the culture wars. So there's been legislative attempts to create more restrictive rules for so-called DAFs relative to other registered charities or tax-exempt organizations in the US. And there's current dialogue in the States right now about even imposing a tax, not just on donor advised funds, but on all charitable endowments. So you see that this is part of the general environment right now. In Canada, we've really emphasized grounding donor advised funds within charitable law, within the Income Tax Act. And hence, we tenderly, where we're going as a committee or as a working group, is focusing on language like foundations with donor advised funds or donor advised fund foundations. Holding charity is also quite appropriate, as mentioned by Terry and Jackie. So the emphasis is on charity and charity obligation and charity law obligations in the Canadian context. This is a very practical operating consideration. Terry, next slide, please. So in Canadian law, and this is more from something that we remind ourselves, and I think a lot of foundations with donor advised funds really focus on. And there's a bit of an echo back to Jackie and Terry's comments, but foundations, first and foremost, must be exclusively charitable and dedicated to their own charitable purposes. And so the boards have a fiduciary responsibility. They have oversight over all the charitable property that's owned by the foundation. So every single DAF is owned. And that direction and control that was previously mentioned is absolutely essential. And this means that the boards have to have policies on investments, policies on grants, policies on programs, and decision-making powers around all of these things. So the notion, and building on the idea that the DQ or disbursement quota, which was so, I think, ably described, is at a charity level. So from an operational perspective, there's been a lot of discussion about, does a foundation need to impose minimum annual payout rates at a fund level? Not according to the disbursement quota, but if you go back to this notion that the board needs to have direction and control, that the foundation must be exclusively charitable, most foundations get to the point where they say, yes, we think that every fund should be paying out a minimum rate, and it's not always 5% or 3.5%, but often somewhere in between, which is a long tradition in the sector. But the point is that all charitable property is used for charitable purposes, and there's clear oversight. So it's not up to the donor each year to decide whether they'll grant or whether they're not. And so that's part of the very practical investment that a foundation with donor advised funds needs to exercise. So the obligation is also, just building on Terry and Jackie's comments, on the part of the foundation to ensure there's no undue private benefit, either to donors or frankly to suppliers as well. And this idea that there must be fair market value. This can't be, a foundation has to be exclusively charitable, looking through a lens to make sure that suppliers are not unduly enriched is also important, but also making sure that the gift has really occurred, that there's not ongoing control. And that's why language is so important as well. Completely agree with the earlier point on that. And then finally, one of the key things I think among foundations, Canadian foundations with donor advised funds, is of course there's public disclosures through the T3010 under Canadian law. It's just we're into the second year of specific donor advised fund reporting. This is immensely important. But where we're moving to is greater regulator acknowledgement that we need to understand activity in this area, and that disclosure is essential. But more specifically as well, beyond minimum compliance requirements, most foundations with donor advised funds also have adopted a standard of public disclosure. So some share audited financial statements, publish annual reports, things like that, that are standard sort of public disclosure mechanisms within the charitable sector. This is not a legal requirement, but it's increasingly becoming a practical requirement because of the scale of this part of the sector. Terry. So drilling down to the donor experience, I mean, donors typically unify, one of the typically use DAFs partly to unify the planning and their charitable giving. So it's bringing together financial planning, it's bringing together estate planning with their charitable giving. And so this is one of the key benefits, is the practical side of things, is they have a single account that they can I often describe it as separating the process of planning and thinking about what you'd like to contribute to charity from the subsequent act of designating where that money goes. And this is a really important and valuable tool. And all the research seems to indicate and practice is it greatly increases commitment. We find that often our donors, their initial donation, if we work with them over their lifetime, it ends up being 10 or even 100 times or more that ends up going to charity because we can provide full support in that area. And that's often a great benefit from a practical perspective. And a more immediate one is just the flexibility and simplicity of granting. I think a lot of foundations in this space, we have online granting portals. We have a lot of resources and support, getting grants out. And it means that from a donor's perspective, they can provide advice, and often within a few days, that money is being sent to the charity. They have a record internally, and they can see all of the giving that they've been involved with in granting. The foundation, as noted, is responsible for the administrative and compliance issues. This is very valuable. It's that so many of the donors that we work with said, we want to give, we want to be involved. We don't necessarily want to do a lot of administration and compliance. And so private foundations for them really aren't an option. And many of them, frankly, they may not have kids. They may not have somebody to carry on. So having an infrastructure that it becomes quite burdensome really takes away from the joy of giving, but also that integration. So one of the trends is being this link with financial institutions and investment firms, and often an extension of the donor's investment advisor that's hired by the foundation to provide ongoing support, but choosing following a policy that's determined by the foundation. Some foundations have active support for granting. So it's not just sending money out, but doing research, doing agreements and things like that. At Aqueduct, we run, as many community foundations do, community-based scholarships. So we're actually running programs. And so that level of support is very valuable for a lot of donors as well. It also, many foundations can provide support for larger, more complex donations that are often integrated into a estate plan. So at Aqueduct, I mean, we deal with things like even, precious metals and private company shares, real estate, that are hard to give to multiple charities. So hence the idea of a bridge. And then legacy funds, which open the door to discretionary grants. So many of our legacy funds don't have an active successor advisor. It becomes the responsibility of the foundation. So they're not technically donor advised funds if they don't have an ongoing grant advisor. So it's an interesting sort of path of development. And finally, the point of privacy or confidentiality, which was so well covered. Terry. The other thing, a couple of things from a charity experience, I'm looking at grantees. It's a growing source of funding in Canada, about $1 billion in annual grants. And this continues to grow, continue to expand. We're also seeing a lot of charities that are engaged in partnerships with foundations with donor advised funds, actually opening their own funds, charity funds or agency funds. But there's also been an underlying desire for better communication about granting practices and the source of grants. This is really important to acknowledge and for us to get right in Canada. If you're a charity receiving grants, assume a letter is being sent, but now it's often electronic. Where it comes from, which fund ended up sort of initiating the grant is communicated, but we've moved from a physical world of mail to increasingly a world of exchange of electronic fund payment. And sometimes all of this shift and this growth has led to a lot of confusion. It's led to some frustration. For example, if you receive as a charity a personal donation, money from a donor advised fund, is it a foundation grant or is it a personal donation? It's clearly a grant, but this is a persistent question. Are grants tax receipted? No, they're not, because they're coming from another registered charity. There's been some counting questions. So should grants from a foundation that is funded by state donations be counted as bequests by the grantee? The answer is no, because they're grants. But these are persistent questions. And then a few other issues around donor foundation recognition and relationship of foundations to financial institutions. So there's a lot more to be done. And then the final point on this is just, if we can see the final slide, just talk quickly about diversity of practice before handing it over to Nicola. Governance really varies from foundation to foundation, and governance will determine what policies are adopted by the foundation and what a donor advised fund. So minimum fund amounts vary from as little as 5,000 or 10,000 to over 100,000. Minimum annual grant disbursements at a fund level exist in most foundations, but not in all. Public disclosure and recording, as previously mentioned, I think is an important obligation, but it varies from foundation to foundation, and even individual granting practices. Some foundations, for example, don't do agreements with end charities. Some do, but so there's real variety, again, granting to qualified donees as well as non-qualified donees, and also the degree of donor discretion and choice, for example, about investments, which we'll get into shortly, and accepted property. So there's a whole range of different practice. I'm going to stop there and I'm going to pass it over to Nicola, but that sort of sketches out some of the questions that we're addressing.
Thank you very much, Malcolm. And hello, everyone. I'm going to cover some of the key issues that were outlined by the working group that Malcolm mentioned, and many of which you've heard about already today. So DAFs being accumulators and retaining assets, we're going to talk about that as a key issue, about the relationship between operating charities and DAF organizations in terms of granting and some of the tensions involved there, about the many players that take part in investment governance with financial advisors, donors, and DAF foundations having ultimate responsibility. And as we've grown over the last couple of decades, unfortunately, a lot of our donors, our original donors, are now passing. And so a lot more succession and estate management issues and administration make up part of our operational work. And then I'll close with just a review of some of the key responsibilities of foundations. So Terry, if you could go to the next slide, please. So as you can see from the table, the DAF segment of the charitable sector has been growing significantly over the last 15 years in particular. And that growth has caught the attention of the regulators and of a number of senior charity executives in the country. There is a perception, and it's been mentioned before, that DAF assets are not being dispersed and that charitable donations are being held in warehouses for advisors and DAF foundations to gain from and have, by generating fees without dispersing. And the concerns are based, these concerns have been levied with the Senate committee, and they're based on the delay in the benefit to society. Donors are receiving a charitable donation receipt and a tax benefit up front, but charities aren't necessarily receiving their gifts in as timely a manner as they might like. And this concern isn't limited to DAF organizations, but also to private foundations and to larger and more traditional endowment funds. So to address these concerns, the Senate committee was formed, and A number of proposals were made, including to delay issuing the tax receipt until disbursement, to impose a timeline on the granting, and to impose annual disbursements at the fund level as opposed to at the foundation level. However, as you can see from the slide, it would appear that these measures might not be necessary, and I would argue are not necessary, because disbursement levels have been and continue to be over 10% amongst the DAF organizations. That's double what the government recently raised the disbursement quota to. So, and as was mentioned earlier as well, most DAFs will grant both from interest and income, but also encroach on capital to allow people to make larger grants. Next slide, please, Terry. Another key issue that we talked about in great depth at the working group was the acknowledgement that there are certain tensions, and Malcolm has mentioned these too, in our industry between operating charities and DAFs. And we really want to name those out today and to share with you some of the recommendations that the working group has been discussing and is putting forward. So the first theme in that is improving collaboration. By one of the ways that DAF organizations can do that is to provide more educational and informative material on our websites to use for charities to use as resources, by ensuring that the corresponding communications, such as the name and details of the donor, if we're allowed to share it, are included with a grant by way of a letter informing the charity of where the grant is actually coming from. And this is true whether it's by EFT or transfer or by check. And ultimately by identifying a DAF contact for the charity so that if they do have further questions, that they can call us and they can, and to the extent that we're able to share information, we will. The next key theme in this relationship area is about improving stewardship. So by, excuse me, improving transparency, we believe that DAF foundations, by sharing publicly their granting policies, their payment timelines, and as Malcolm indicated, there's little standardization of practice. So the more that a DAF foundation can share about their policies and procedures, the better it will be for helping charities to steward their donors. But there's also the issue about developing strategies that ensure charities can source and manage DAFs. The truth is that there are many charities out there whose donor management systems simply do not enable them to track both the DAF organization, the underlying donor, and the DAF fund name. And this is a cause for concern at charities. It also results in grants and grant letters often being separated. And so development officers are not aware where the funds are coming from. And donors are not receiving confirmations of their grants or communications from the charities that they've granted to, or at least not in as timely a manner as they would like. So there can be frustrations in this on all sides, and I think it's something that we need to work together as a sector to improve. But the one big piece that keeps coming up in the conversations that we have, both with the working group and with charities, is anonymity. Most DAF organizations have three privacy preferences that they offer to donors. One is full disclosure, your name, your address, your contact details being sent to the charitable recipient of your grants. The other is fund name only, which most donors select. which may or may not include their actual name in their fund name. And the third is anonymous. So in truth, less than 2% of grants are really going out on a purely anonymous basis. But the bulk of the grants are going out in fund names. So that can be perceived to be anonymous if you can't immediately identify who the donor is. But it's important for charities to understand that, you know, we have privacy laws. We're offering donor preferences. They love that flexibility. And it's our duty to ensure that we're abiding by those. But still, having said that, there is a lot that DAF foundations can do to improve the flow of communication, to quickly share information that comes from the charity with the donor, passing on thank yous and information that will help to alleviate some of these things. Next slide, please, Terry. So grant administration, I mean, you know, as a donor advised fund organization, we really are large grant making organizations. And I'm going to cover some of the operational complexities that we have to deal with. Usually the first step in issuing a grant is to verify that that the grantee is a qualified donee. But now, as you've heard, we have new qualifying disbursement rules that allow certain organizations, if their objects comply, to make grants to non-qualifying donees or other not-for-profit organizations, for example. But doing that comes with a guidance document that requires many steps. And as Terry mentioned, there's a risk matrix and there's compliance and accountability tools that must be used in that regard. So we have to be able to assess if the qualifying disbursement matches with our charitable purposes. We have to conduct research about the non-qualified donee, including online publications, secondary sources, articles, bylaws, financial statements, all kinds of information, and then make a decision as to whether or not to proceed. In which case a grants agreement needs to be put in place, approval signatures from the foundation and the grantee, and then ongoing monitoring compliance. It sounds a lot like direction and control from you know, international gifts, and it is a considerable amount of work for those of us that are taking this on. But in addition to that, you know, the administration of grants involves a number of steps and it takes some time. So we usually say that we work to 10 business day turnaround. It's often faster than that, but we have to receive the communication, record it in our system, confirm the qualified donee status or this other road that we may take on the grant, request the funds, receive them, and then issue the check and or EFT and a corresponding letter that will help the charity to understand what the donor's intentions were. So there are quite a few steps involved in it, including confirmation of disclosure requirements and addressing privacy issues which we've mentioned, and making the actual payment, which Malcolm talked to. There is a push across the sector to move to electronic funds transfer as opposed to check for a number of reasons, security, and the fact that, you know, reliability of Canada Post is diminished significantly. And lastly, on this slide, international granting is something that, whilst Canadian charities can't do, there are some organizations that specialize in internal granting programs. And we can, in some cases, help donors who want to make grants to their home country by partnering with those organizations. But that too involves quite a bit more administration and additional fees. Next slide, please, Terry. So Malcolm said we were going to talk a bit about investment governance and financial advisors. And so there are sort of three main areas in this category that was discussed at the working committee, and the first of which is about donor direction. The Provincial Trustee Acts oblige charities to exercise fiduciary control over their investments. And the ITA has similar conditions that require us to demonstrate that a donor does not control assets that have been gifted to the registered charity. Both of these are addressing concerns that the regulator have that if the donor continues to control the asset, then there wasn't really a gift. And this, to harken back to what Jackie mentioned, could jeopardize the donation receipt should they be deemed to be in control of the gift that they've given. So that's a key issue for us. Fiduciary duty is another one. As we've said, DAF foundations have this responsibility and therefore should have an investment policy statement that talks to what its overall investment strategy and objectives are. And they should also have a process in place to ensure that the assets comply with that policy by reviewing it on a regular basis. So traditionally, the minimum goal was to generate sufficient returns so as to allow the grants to continue to be made and to cover fees and inflation. But exceptions can be made to that. And even recommendations can be accepted by the DAF advisor in regard to it should the DAF Foundation choose to agree and accept those recommendations. For example, investments in private equity and impact investing is another hot topic these days. However, recent research has determined that outside of a few foundations, mainly private foundations, carving out allocations to do these less conventional investment activities, there are few donor advised funds at the moment that have allocated impact investment solutions for DAF providers, for DAF donors by DAF providers. And similarly, there is not significant interest coming from the DAF donor population. So these research groups are looking at ways to explore opportunities for wider adoption, and we will see how that goes. But the other key point that I want to make on the investment governance is about the role of the financial advisor and the role of the DAF advisor. They are different roles. The DAF advisor is the person that is allowed to give grant recommendations on the fund. The financial advisor, on the other hand, can play various and sometimes multiple roles. They can be an educator to their clients, educating them about different opportunities and gift planning vehicles and their benefits and their drawbacks. They can be a referrer, introducing a client or a donor to a DAF foundation, from a firm that is not affiliated with the foundation. Or they can be an agent, which we see a lot of, where we have an introducing in-house staff program offered to clients of the firms that we work with, in which case the agent, the advisor would be paid on an ongoing basis, or financial advisors can just act strictly as investment managers, whereby they are managing the assets of the foundation in accordance with its policy. So many roles played by the financial advisor community and the legal community in the DAF world. Next slide, please, Terry. So we've talked a little bit about succession and estate administration. So in terms of succession, once a DAF advisor passes away or becomes incapacitated, the responsibility for providing grant recommendations normally will fall to what we call a successor, which is a person named by the original donor as the one that they want to take over when they are no longer able to provide those instructions. That's usually a family member. It could be an executor. It could be the financial advisor, or it could be, a friend. But if there is no successor named, the fund becomes an orphan, really, and the foundation is responsible to continue to use those assets for its charitable purposes. These were, Malcolm referred to them as legacy funds. Most DAFs have policies in place to ensure that these assets are distributed to the charities previously selected by the donor or like charities. So that is, generally speaking, what will happen there. DAF termination and DAF transferability are two other important things that you should be aware of. The working group agreed that there should be written policies in place to determine situations, particularly where a donor requests a 100% disbursement to a charitable organization or a transfer of their DAF from one DAF foundation to another DAF foundation. Regardless, and that does happen quite a bit in the financial advisor community as advisors move from one firm to another. That process should be in writing, the committee, the working group had agreed. But either way, it would usually involve the liquidation of the assets at one foundation and a transfer of cash to the next by way of a grant. Another issue is that DAF foundations are not subject to divorce or separation. We have to adhere to our donor agreements. So some of us would split a fund, but it really depends. Wills are very important. Many more people are leaving funds via their will to their DAF organizations. And donors like the flexibility of that because particularly when they are giving to multiple charitable organizations. And finally, powers of attorney and executors, they don't generally, unless they're named a successor, have the ability to make a grant from a DAF, but they can make estate donations on behalf of the estate if they're granted sufficient powers in the will to do so. Ultimately, it all boils down to the donor advised fund being a very flexible vehicle in terms of estate planning, and that's why Canadians and their financial advisors and their legal advisors tend to like the structure, which is why I think it's so popular. So now, Terry, if you could move to my final slide, which is about just a reiteration of our responsibilities. We have fiduciary responsibility and retain all the legal rights and responsibilities for managing DAF assets and for making grants, as was mentioned before. It's very important that we as DAF organizations ensure that our donors are made aware of that at the very outset. Donors don't really have any obligations in terms of compliance or reporting, and usually the DAF Foundation will provide a statement on a regular basis that will indicate the size of the fund, the grants that have gone out that period, and any donations that were made into it, but not necessarily share the investment statements because those are investments now owned by the DAF organization. That is at the discretion of the foundation. Each foundation, as Malcolm mentioned, has got their own terms that they will agree to, minimums and maximums, both in terms of granting and in terms of initial contributions, different investment options, and different fees. But the key responsibility is to ensure the foundation meets its annual disbursement quota. And remember that this is at the foundation level, not at the fund level. So that's really it from us. Our presentation is complete, and we're going to move forward with some frequently asked questions, as Terry indicated. But before we do, could you advance one more slide for me, Terry? We have put together a list of resources for you to come back to learn more about donor advised funds in general and what's happening in our sector. There's some research pieces, some articles from Malcolm, and a presentation from Jackie as well listed there. And I would also remind you that the working group will be publishing via CAGP a sector review and some key stakeholder pieces for charities, for donors, for advisors, and for DAF foundations. So you can look forward to that in the fall, I believe. Anyway,
Great.
thank you.
Well, thank you very much, Nicola. That's great. And we are going to move over now to our Q&A session. Pretty well on time. So we're going to just kind of pretend that we're around the fireside for a fireside chat, or maybe we're out in the backyard with a fire with marshmallows. So we're just going to have a chit chat back and forth. So I'm going to go through questions for each of you and see how many we can get in the next 10 or 11 minutes. So Jackie, we'll start with you. What are some of the practical applications that you've seen that DAFs have been used in your practice?
Great question. A few different ways, well, actually a lot of different ways, but a few that I'll highlight. Often we'll have charitable clients who are sort of in discussions with a donor and the donor wants to fund a capital project at the charity or something else. And so they're in the process of working out the terms of that agreement and naming rights. And often the monies that the donor will use will come from their donor advised fund at one of the DAFT holding charities. So the DAFT holding charity needs to be part of that process and a party to that agreement. That's one way. Another way, we have clients that come and want to set up a brand new charity. Great goals and mission. It just takes time to set that charity up, at least a year between incorporation and mainly getting charitable status. And they have people who want to support them in that intervening year till they can get their charitable number. So often they will set up a DAF with similar purposes to their prospective charities. They can get supporters who can support the project through their DAFT. And then once the charity is in place, there can be a grant made from the DAFT to their charity or a change of trustee to move that fund over to the new charity. We also have charities who are active charities. They may have built up a bit of a nest egg, doesn't make a lot of money on its own, and they want to set up a type of legacy fund. We call it an organizational fund. Sometimes it's called an agency fund. They'll set that up with the DAFT. They'll move their monies into it as well as encourage their supporters to contribute to the DAFT. And it becomes a longer term endowment or long-term fund that makes more income because it's combined with the larger assets of the community foundation or the DAFT holding foundation. I've seen a number of charities do that. And while we were talking earlier, Nicola had talked about that there's private family foundations that as they grow in age, they may actually want to transfer over to a DAFT holding foundation. I wondered if you wanted to speak to that briefly, Nicola.
Sure. It's just that I've had a number of conversations in the past year with family members who have inherited a private foundation from, their parents usually, and either the charitable objectives are not what they're truly passionate about, or they just find it burdensome to administer the charity on an ongoing basis. And so in those cases, people have elected to transfer the assets and just continue the legacy, but just in a different vehicle.
Okay. Thanks for that, Nicola. And thanks, Jackie. Over to you, Malcolm. Some charities are listening in. They're thinking, maybe me too. So do you need to be a large charity in order to set up a DAF account?
There's no legal restrictions, but there's many practical ones. One of the big challenges, I think, is it's a highly competitive space. There's a lot of administrative infrastructure that's required, a lot of governance. So just because this is an area of significant growth don't underestimate the responsibilities associated with it, and some of the challenges around implementation and connection with donors and just ongoing operations. One of the challenges as well, there are operating charities that run donor advised funds, and some do it well. Most of the programs are fairly modest. Sometimes I'm talking to colleagues, there's a challenge of attention, time and attention, a little bit of mission drift. If you have a core mission or are also encouraging your donors to give potentially anywhere, that can create internal tensions around those donated resources. So there's a lot of associated challenges, but again, I would sort of reiterate Terry and Jackie's advice. Have that discussion with legal counsel first before you leap into it.
Okay, thanks, Malcolm. Nicola, you talked a little bit about sharing donor information. So can a DAF charity share donor information with a recipient charity? And if so, what needs to happen?
Well, the answer is yes. It depends, really. Most DAF organizations.
A good lawyer's response. I like it.
Exactly. Most DAF organizations allow the DAF advisor to choose their preference, their privacy preference, as I mentioned before. And so share as much information as we can based on that privacy preference that we're given by the donor. And but as I said, I think there's still a lot more that donor advised fund organizations can do, including offering to pass on thank yous and send more information on to the donors as quickly as possible for the charitable foundations to be able to steward in a better manner.
Great, thanks. Jackie, back to you. You talked about restrictions. So can you give some examples of different types of restrictions and from a practical context that donors could impose when setting up a DAF?
Sure. Yeah, there's a wide variety. Some donors like to set their DAF up to be an endowed fund where the capital is held in perpetuity and only the income is used, or they could set up long-term funds where the capital is held for 10, 15, 20 years and then is able to be expended after that period of time. It allows the income to grow and develop. Alternatively, there can be no restrictions on time. The capital is able to be used going forward together with any generated income. Then on the use side, they can leave that unrestricted and allow greater flexibility in how income and capital is used from the DAF to a variety of qualified donees, or they can restrict it to particular charitable sectors, or they can leave it open while they're there, while the donor's giving advice, but when they're no longer there, then they could maybe restrict how the DAF holding foundation uses the income and capital if they want. Those are just a few of the options. There's lots of flexibility there.
Okay, thanks, Jackie. So Malcolm, tell us a little bit about your observations about DAF holding charities becoming involved in offering impact investing that's being referred to by Nicola. How prevalent is it? What are some of the issues that you see there?
So there's growing interest in impact investing. This is individual charities taking investment assets and putting it in mission-aligned organizations with the hope of getting earned revenue or some sort of equity growth over time. It's an important area. The basic sort of analysis is if you're distributing 5% of your assets, what's happening to the other 95%? Is it aligned? So this is the community foundation movement's been particularly strong in this area and has been ahead of the curve. But I think there's increasing interest But there's challenges. It depends on the foundation. There's a lot of administrative and oversight issues because you're typically dealing with, even if you're dealing with intermediaries that are aggregating these investments, there's a different kind of oversight than you'd have in the public markets. But it's often perceived to be a very important area and as something that what we call program-related investments in the Canadian system are important, getting that lift and mission alignment. So I think we'll see more of it in the future.
Thanks for that, Malcolm. And we do have a link to materials we put out on some of the challenges associated with impact investing. Not that it can't be done, but it has to be done carefully. So thanks for that. Nicola, we got 30 seconds. I'm going to ask you a question. And here it is. Get a DAF donor sign a pledge agreement to make a gift to a recipient charity.
It depends.
Love it.
It depends on the charity and their policies and whether or not they will allow it. I can speak for benefaction. We do allow it. We require a 3-way pledge agreement, and we also impose a clause that says that we will meet this pledge agreement provided that there are sufficient funds in the donor advised account. Other organizations, however, I know do not sign pledge agreements, but they can, of course, set up annual payments to go out to the charity of the donor's choice. So in some ways, that's achieving the same goal.
Perfect. Thank you. Everyone got 2 questions. This is great. We're right on time. So first of all, I want to thank the 3 of you, for Malcolm and Nicola and for Jackie, for your presentation. Also, just want to put a word in for our team at our office, Jennifer Kirchhoff and Jen Thistle and Sunil Patil, in putting things together. Wouldn't have happened without them. And just a little plug, we do have our annual charity and not-for-profit law webinar coming up on November the 13th. That's not too far away. It's on a Thursday. We'll be having more information coming out. Hopefully this has been of help to everyone. And if you want to contact any of the presenters, you've got the contact information. Thank you very much for being with us today. And this was intended to be helpful educational materials for the sector. And we really do appreciate your participation today.